Good afternoon, everyone, and welcome to today's exclusive webinar from VisaNation. I am Vishal Rai, CEO of VisaNation, and I'll be your host and moderator for this very timely webinar today. As many of you know, about 12 days ago, the government announced a monumental change to the H-1B visa program, a new $100,000 fee on new H-1B petitions. Now, this is one of the most significant policy shifts related to employment immigration that we've seen in many years. This announcement has left many or all of US large employers who routinely hire foreign employees in various professions, as well as foreign workers and international students across the US with lots of unanswered questions. For example, who exactly needs to pay this $100,000 fee? Does it apply to renewals or transfers? How do you actually make this payment? And could this be challenged or even blocked in federal courts? Now, these are all important questions, and we'll unpack all of these today. I'm joined by two of the top attorneys here at VisaNation, and together they have 4 decades almost of combined experience with complex US employment immigration policies and regulatory changes. We'll walk through what new changes are confirmed, what's still unclear, and how you and your employer can best prepare for it and have a actionable strategy ready. Before we begin, a couple of quick housekeeping items. This webinar is being recorded, and we'll send a replay link and a short summary by email to all of you by tomorrow morning. Please feel free to drop your questions in the chat on LinkedIn or YouTube as we go. We'll take as many questions as possible towards the end of this webinar in our Q&A portion. And with that, let's dive in. First, let me introduce Shilpa Malik. She has 2 decades of experience with U.S. corporate immigration. Shilpa, welcome.
Thank you, Vishal. I appreciate the opportunity to be a part of this webinar. I'm the managing attorney at VisaNation Law Group. First and foremost, let's all take a collective deep breath. I know this is a lot to take in and came as a massive surprise, or should I use the word shock, to a lot of people who obviously consider the H-1B as the most important work visa that's available to talented individuals from overseas. That being said, my colleagues and I have tried to break it down for you. And while there are still some questions that we do not have answers to, we will make the answers available to you as and when they become available. And with that, I would like to extend a thank you. Sorry, Vishal. I was just about to say that I would like to say a thank you to all the existing clients of VisaNation who have likely joined this webinar, and any new participants. We are excited that you're a part of this webinar.
Thank you, Shilpa, for the introduction and bringing light to the significance of this and being available today to answer these questions. So let's start with the most pressing question we have. What is the scope of the recent H-1B fee proclamation? Who exactly does it apply to, and who is exempt?
Yes, that's a very good question. The proclamation that was signed on September 19th, late in the evening, I remember it being a Friday, essentially affects H-1B petitions for individuals who are currently outside the United States. That's a very important point to remember. So individuals who are present in the United States at this point in time, whether they are currently on H-1B or are looking for a change of employer while on H-1B status, or are seeking an extension of their current H-1B status, or if, let's say, they're eligible for filing a change of status to H-1B, those individuals are not subject to the proclamation based on the plain wording of the proclamation. So again, let me reiterate, it applies to individuals who at this time, or rather as of September 21, were outside the United States and are currently outside the US.
Okay, that helps for the current H-1B petition holders, because in the beginning there was some uncertainty whether it's applicable only to new petitions. I think the administration clarified over that weekend that only the new petitions are subject to this.
New petitions is a very loosely defined term. New petitions generally mean people who are, again, who have to go through the lottery in 2026 for the next fiscal year. They would fall under the new petition category. Or it also applies to individuals who are presently outside the United States. And let's say they're applying through a cap-exempt employer or a university, and they've never held H-1B status before, or are seeking H-1B status at this time and are outside the US, they will be subject to this. So any individual who's outside the US has a petition filed after September 21st will be subject to this proclamation.
And one follow-up to that question, Shilpa, is what happens to those foreign workers who are near the end of their 3-year period of initial H-1B and they are about to file or have filed for the next 3 years?
Again, extensions are not subject to the proclamation. I would like to reiterate, extensions, amendments, change of employers, which are generally loosely called as transfers, are not subject to the proclamation as long as the individual, or rather the employee, is in the United States.
And just to clarify, whether a foreign worker is staying with the same employer during this quote-unquote extension or transferring to a new employer, the same guideline applies?
Yes, that is correct.
Okay. All right. And are cap-exempt employers like universities and nonprofit research organizations impacted by this new proclamation?
That's a very good question again. Any entity which is a nonprofit research organization, and remember, they have to be a qualifying cap-exempt entity. So a nonprofit entity that is fundamentally engaged in research, or a public or private nonprofit university can still continue to file cap-exempt H-1Bs for individuals within the United States. I want to reiterate that USCIS hasn't provided any exemption yet. And again, we have to go with what the proclamation says as of today for individuals who are outside the US. So for example, if a cap-exempt nonprofit research organization or a university wanted to bring in, let's say, a researcher from India or any other country outside the US, they will likely be subject to the proclamation because USCIS hasn't announced any exemptions for those categories at this time.
Okay, so I think by this point, everybody has enough background on this. So let's switch gears a little bit and talk about the Project Firewall. Could you define it first for our viewers, Shilpa, what it is, when was it announced, and anything else you want to add?
The Project Firewall was announced last week by the Department of Labor and USCIS. Essentially, how does it impact H-1B holders or employers is what we need to look at. To some extent, even F1 students who are currently working on OPT or STEM OPT might be impacted by it. What it really means, it's an enhanced compliance initiative of USCIS and the Department of Labor. It heavily scrutinizes any third-party placements, let's say by staffing companies or even by entities who provide services on a client basis, where they place a management consultant or other similar worker who's on H-1B with another client at another client's site. It will also look at staffing arrangements, whether a valid employer-employee relationship exists. The public access files, the LCAs, will be closely examined during a site visit, if any. Additionally, the DL will keep track of the wages being paid to the employee, making sure there's no benching happening and the wages are in compliance with the labor condition application that was submitted at the time the H-1B petition was filed and subsequently approved. So it's more of an initiative to ensure there's strict compliance where both the employers as well, the H-1B employers that is, as well as the workers to comply with the terms of the H-1B that was approved on their behalf.
Okay, that's a good background on Project Firewall. Let's talk about the intent of this a little bit. Is this primarily meant to detect fraud in the system as far as hiring foreign nationals on H-1B goes, or does it is it meant to limit mobility between employers?
It is primarily meant as a tool of fraud detection, but at the same time, it clearly does create, it becomes a gatekeeper on mobility as well, because when there's obviously a concern that you're being watched at all times, of course, that leads to generally greater compliance. And we always advise our clients to stay on top of their documentation. We assist them with ensuring that their documentation is in line with the Department of Labor and USCIS requirements and warn them if there's some deficiency. But this will be more of a heavier scrutiny whereby employers will maybe, again, employers will be like, okay, this is too much. Not sure we want to go down this path.
Yeah, makes sense. And in the current environment where the tech workers in some specialized industries like artificial intelligence, data scientists, biotechnology, they're in high demand, and many of them may have concurrent H-1Bs. How does this initiative, Project Firewall, affect them and their plans?
Well, concurrent H-1B can be filed if you're working for a primary H-1B employer and then you want to simultaneously work for another employer in a field that is closely related to your degree or qualifications that equate you to being an H-1B qualified employee. So when you file a concurrent employment, the question again becomes, have you complied with the terms of your existing H-1B before a concurrent H-1B can be approved? Now, how are you going to manage your role across both employers? How many hours? So let's say your first H-1B was 40 hours and the next one's going to be, let's say, 20 plus hours, the concurrent one. So USCIS will have a legitimate question there. How are you going to put in 60, 70, 80 hours of work for a concurrent employment? So then they'll obviously come knocking on doors, show us what you're doing, what's taking up your time, etc. Show us the actual H-1B qualified work that you are performing under both employers. And the employers will also be required to provide information that this is something that we've assigned the employee, this is within the H-1B responsibilities as was listed on the H-1B petition.
So in plain translation, at all times, the compliance becomes very important for employers and employees.
Absolutely, because we've had news reports of USCIS conducting more and more site visits. Therefore, I do strongly advise all employers and employees to check the terms of their H-1B filings and ensure that they're in complete compliance so that they're not caught unawares.
Okay, so next hot topic on everyone's mind is the new proposed wage-based lottery system. Can you give us some background on this, Shilpa, first? Like, what are the key differences between this proposed wage-based lottery system and the current random system that's been in place for many, many years?
Well, technically, the random lottery-based system only started about 4 years ago. And the basis of that lottery was to essentially ensure that employers submitted registrations beforehand and not have to submit entire packages of filings, not knowing whether their candidate would be selected in the actual H-1B cap or not. So it was just to sort of reduce paperwork and filing fees when the applicant has not even been selected in the lottery. So that was a good the motivation behind the lottery system was obviously good. Now, last year, USCIS changed the lottery system to allocate lottery numbers based on the beneficiary's passport. So you could, if the beneficiary's passport had 5 other employers applying for a particular beneficiary, the beneficiary's passport would be entered one time in the lottery, so as to not get increased chances in being selected. So that was a change USCIS made last year. But now, under the wage-based lottery system, the intention of USCIS and the current administration is that the higher you pay, the more likely you'll get into the lottery, in very simple terms. So there are 4 wage levels that are in the Department of Labor wage level guidelines. Level 1 is usually for entry-level positions. Level 2 is for people with maybe 1 or 2 years of experience and perhaps a master's degree in the field. Level 3 is for individuals who are more lateral, mid-level employees who've banked in a few more years of experience along with their degrees. And last but not the least is level 4, who are more management level, senior employees, very highly sort of in-demand employees. Now, what this really means is, if you were to register a candidate as an employer for the H-1B lottery, you will now be required to list the wage level that you would be paying this individual as part of the registration form. So let's say I'm looking to hire a software engineer in California, and let's say Los Angeles, then I will have to see, if I put the software engineer at level 1, that software engineer candidate will have only 1 chance at the lottery. But if I'm willing to pay them a level 3 or level 4, the software engineer application or registration will get 3 bites at the apple, which is 3 chances at the lottery or 4 chances at the lottery. So that's where the difference lies. This is basically to increase the wages that are paid to H-1B workers. And again, this is subject to a lot of disagreement amongst a lot of the immigration folks.
Yes, indeed. It is a big change from the current system. And one has to wonder whether the government has a strong preference for employers to hire highly paid and more experienced attorneys who are in these higher wage levels as opposed to the lowest ones.
Yes, that's a very good observation. I would like to add that people have to start somewhere. There are going to be entry-level positions. Now, if I graduate from, let's say, from a particular university in the United States with a master's degree in computer science, I just graduated. I'm not ready to be hired at level 4 because my level of responsibilities cannot be at that level. Yet, I would be an asset to the employer because I'm doing work that is critical for me to build up to that level, or critical for the employer to build software tools or products, as the case may be. So I think this is not a fair system, if you want my honest opinion. I guess it's more of a deterrent and more sort of, it's sending the message to the employers that unless I pay a crazy amount of money, I'm not going to be able to get the candidate selected in the lottery. So let's focus my energies on finding a U.S. citizen worker or possibly somebody who's a green card holder. But at the same time, the talent pool is extremely limited in that group of people.
Yeah, and there's been a lot of chatter and concerns all over the internet and LinkedIn and forums that certain employers who have a large part of their workforce, especially in tech, made up of employees with less than 5 years of experience, for example. One big pool, for many companies is international students, especially from STEM subjects, majors. It puts them at a disadvantage. What would you say about that?
I would agree with that 100%, because at the end of the day, we as America have always been in favor of attracting global talent, which is why we are where we are in terms of innovation and invention and discoveries, and we basically are the first ones to come up with, groundbreaking AI tools or other medicine research or whatever, or other related fields where intense research is required. So unless we give the individuals the opportunity to come to the United States and work on those fields, knowing that they have a future in this country, we are going to lose that talent. And I hope there will be this conversation at the level where Congress will intervene or federal courts will intervene and try and make this process easier. Not everything is wrong with what's being done, but it needs to be done properly in a way that's supportive of American workers, but also does not deter foreign talent.
Yes, indeed. The last question I have about the new proposed weight-based system is that uh, does it seem to favor any certain industries or geographical locations, perhaps more than the others?
Well, again, it's not an easy question to answer. For example, what is considered a level one wage in New York City or let's say Los Angeles will likely be a level three wage in Alabama or Arkansas. So but most employers who are in these major fields tend to work out of bigger cities, whether it's Seattle or Washington, D.C., or New York or Dallas or Miami or all the big cities in the United States, mostly in Silicon Valley. The wages there to attract that kind of talent, I believe, with rather tech companies that are up there, is relatively high. So they definitely have that advantage, where startups who are coming up with beautiful ideas and probably greater innovations are being held back because they may not have that much room to provide a level three or a level four wage right at the outset.
Thanks for providing these details related to the new weight-based system, Shilpa. At this point, I would like to introduce attorney Katiana, and she has over 15 years of experience in U.S. immigration law. And welcome, Katiana, for joining us.
Thank you for having me. I'm happy to be here. I'm happy to clear up as much as we can with as much information as we currently have at this time.
Yes. So the first question I have for you, Katiana, is the federal court interventions. There's been a lot of chatter related to whether this current proclamation is going to stay as is, or is there a fair chance of this being challenged in federal courts, which we've seen with many other executive orders from the current administration. So what kind of federal lawsuits, if there are any, have been filed against these changes?
At this time, there have been no lawsuits that have been filed. We do expect that they are forthcoming, and a lot of courts have seemed to be open to the idea of these kinds of lawsuits based off of different cases they've placed injunctions on in the past. But at this current time, there are no lawsuits that have been filed. This is something that we are closely monitoring, and we do expect this to change in the coming weeks. But as soon as we find anything out, we'll definitely be letting everybody know.
And how quickly could a federal court injunction overturn or pause any parts of this proclamation, hypothetically speaking?
Hypothetically speaking, if a plaintiff were to win a preliminary injunction, enforcement could be halted within weeks. But appeals can prolong this uncertainty, and outcomes can differ between circuits. So again, it's a moving target. It is something, as situations arise, we will be reporting back and letting everyone, the VisaNation family, know. But it would be able to halt it within weeks. But that is something that, again, it's circuit court dependent, location dependent, and outcome dependent, and appellate process dependent.
Okay, that's important for our viewers to know that they should look out for any announcements related to any challenges that this proclamation may face in federal courts. Now, let's change to something different. There are certain exemptions that were announced within the last 7 days. One particular exemption that's been talked about more than perhaps anything else is national interest exemption. So what qualifies as a national interest exemption under this current framework?
Right now, as far as any kind of written guidance has been released, the proclamation does very loosely state that there may be some people may not have to be susceptible to the 100,000 payment if their hiring is deemed to be within the national interest. Now, that is as far as any kind of guidance has been given. USCIS, DOJ, DHS, nobody has released further guidance on what is to be considered fields that are within the national interest. Now, until we have specific guidance, there is no clear-cut way to determine what's going to be considered within the national interest or not. Basing it off of current trends, if we like to, basing it off of what is considered in the national interest in cases, EB2 and IW cases at this time, we think it may be in areas that are fields of law, that fields of industry that are healthcare, things that are in the welfare, things that the governments have decided are of important merit. But until actual official guidance and regulations and further details have been provided, there is no certain way to know, and there's no certain way to be able to determine if somebody would be considered within the national interest or not.
Okay. And since a lot of the details are unclear, would you be able to comment on how long the adjudication for this exemption might take?
It's impossible to know. We don't even have guidance on what the process would be to apply for this. So we're uncertain if it would be an additional portion of the H-1B that would have to be applied, if it would be a follow-up, a waiver that would have to be done, or if it would be something that would have to be done directly with the consulates. So until we have more information and more direction, it's impossible to know how long a process would take to apply.
So just like the lawsuit-related questions, our viewers are advised to continue to watch the developments for further details related to these exemptions.
And just, if sign up for our newsletters, keep up with us. We will be releasing information as becomes apparent to us. So as soon as we know, we'll let you know, and keep your ears peeled, because things are changing and regulations are being released at an exponential rate.
Yes. The next set of questions I have for you, Katiana, are travel related. During that weekend of September 19, there was a lot of confusion, chaos. There were all types of predictions by not only the H-1B visa holders, but even some practitioners, whether people who are outside the US, they'll be allowed to return starting that Sunday. Now there's more clarity around that. So could you educate our viewers on how the international travel plans of H-1B holders may get affected?
At this time, the proclamation itself does not prevent any holder of a current H-1B visa from traveling in and out of the United States. The proclamation is written directly affecting entry to the United States for individuals who have not yet obtained the H-1B as of the effective date. So if there are any individuals who have not yet obtained their H-1B, who don't have a stamp yet in their passport, we would advise against international travel at all costs, and until more information is released. But as the proclamation is written, it is affecting only H-1B holders outside the United States who do not have passport stamped in their passport and who did not obtain their H-1B prior to the effective date.
So just to confirm once more, this recommendation of avoiding travel applies primarily to those who have an approved H-1B visa, but it's not, the visa stamped is not on their passport yet.
The recommendation to refrain from travel, I think, should be applied across the board. It directly affects individuals who do not have an H-1B approved yet and do not have a stamp in their passport. Individuals who do have H-1Bs or do have stamps in their passport, I would advise to travel with caution, and before taking any kind of international trips, to consult with your immigration attorney to make sure there are not any upcoming changes that will directly affect these travels.
Yes, that's very important to keep in mind when booking any international travel. Question on this is, how are the dependents of H-1B visa holders, so those who are on H-4 status, like spouses, children, how are their plans related to travel or work in the US are affected?
Since the H-4 visas are directly tied to the principal H-1B holders, anything that applies to the H-1B holder may be susceptible to the H-4. So if the H-4 holder has not yet obtained the stamp in their passport, they don't have a visa in their passport because the principal H-1B holder does not, then they should also avoid travel because they may be susceptible to showing proof that the H-1B holder has paid the $100,000. So same rules, I would suggest the same kind of advice. H-4 holders who currently have stamps on their passport, who have the visas, technically are not affected at this time. And it would be people who are coming in who are going to be obtaining their H-4s for the first time. Because again, the H-4 is a dependent visa and it is directly tied to the principal H-1B holder. So if the H-1B holder has any caution, if there's any reason that they should not be traveling without making the payments, then the H-4 should heed the same advice.
Okay. Well, the last couple of questions I have are for Shilpa. This has been a common question that VisaNation has received from many of the existing clients as well as prospective clients. So this is about the alternatives. A lot of people are now showing more interest in other categories, for example, O1 visa, L1 visa, and even investor visa if they can qualify. So could you talk about that, Shilpa, and provide some background on these alternatives to our viewers and when it might make sense for certain people?
Absolutely, happy to do so. But before I go into that, there was one point that I wanted to further reiterate on the federal lawsuits. It's very important for the employers and affected applicants to assume that the proclamation as it's been drafted stands until there is an actual injunction or order in place that either stops it or overturns it. So please prepare accordingly. Just don't assume that a magic wand will be waved and all of this will go away. We are sure hoping that it will be controlled, but until then, please assume that you are impacted by it to the extent that it applies to you. So that's just a word of caution from our side. There is a lot of talk in the immigration lawyer community and lawsuits are imminent, but until there's an actual order by a federal court, and again, as Kachana rightly pointed out, there will be likely appeals from the current administration to any order blocking it. Please be on the vigil. So I just wanted to ensure that you all are very clear on that. Thank you. And I would now move on to the question that Vishal had asked about alternatives. Interestingly, Vishal, we've received many inquiries in the last 10 days from individuals who are now like, okay, maybe the H-1B is no longer reachable for reasons that apply in different scenarios. And they've asked us to review their credentials for a possible O1 and maybe an L1 if it's a multinational entity which can afford to send one of their key employees to a foreign office to work there in a managerial or executive capacity, or as a specialized knowledge employee for 1 full year. That's important to remember. The L1 can only be filed by multinational entities who have a foreign office and who have the capacity to send a US-based employee, or maybe want to bring in an employee who is currently overseas working for their foreign office to work in a managerial, executive, or a specialized knowledge capacity. And 1 year of employment overseas is mandatory. It cannot be performed from within the United States. Something to remember. So that's, they come with, all of these visa categories obviously have their own requirements, and also they have their own prerequisites. So please keep that in mind, and you need to qualify for all of them. And the O1 is for the extraordinary ability category. While I'm sure everybody really works hard in their field and is trying to do the best and get the best achievements that they can, the level of extraordinary ability that USCIS is looking for in O1 is very high. And USCIS is very, very cognizant of the fact that people who will likely be, not able to pay, or would not want to pay the $100,000 fee are now going to really go after the O1s if that's a possibility for them. And those O1s will then be scrutinized a lot more to assess an individual's achievements, both nationally, internationally, have they risen to the top of their field, et cetera, in the position that they are looking to be hired, whether this is a bona fide employment, et cetera. So again, if anybody's considering sort of any alternatives, please consult with your immigration attorney, or if you need our support, please reach out to us so that we can assess your cases individually to determine if it's a possibility. On that note, very quickly, there's also other visa categories such as TN for Mexicans and Canadians, but the profession has to be on the TN occupation list. Not all positions qualify for a TN, and there's some very specific qualifications needed for those positions. There's an E3 for Australians, which is pretty much a sister of the H-1B, but it's only available to Australian nationals. There's the investor visa, and if your country has a treaty with the United States, you could potentially set up an entity in the U.S., make an investment, a substantial investment, and then get the E2. But again, this is a case-by-case analysis. This is not one size fits all.
Many good points there related to the alternatives. So just to summarize, those who are on the H-1B but are looking to change employers, and also those who are perhaps international students or on any other visa category and were planning on using H-1B visa as their next step in their professional journey, it would be wise for them to consider other alternatives given all the uncertainty.
It is definitely wise, but you also need to acknowledge that you may not necessarily qualify for it. Definitely consider all options, but whether or not you qualify for it is a professional assessment, which can only be conducted by a qualified immigration attorney. I want to add this here. ChatGPT is not an immigration attorney. Google Gemini is not an immigration attorney. And Google Gemini and ChatGPT tend to agree with whatever you feed into it. So just because you put in your resume and you're like, do I qualify for an O1? Does this look good for an O1? It's going to just say, yes, it looks good for an O1. And maybe just a few areas of improvement. Please do not rely on those sources and not let them decide your life or your visa courses. Please consult with a qualified immigration attorney.
So in other words, they need a professional with decades of experience who is not going to agree with them on everything they say.
Yeah, because we're here to watch out for them. We're here to ensure that our clients are represented the right way and are able to possibly get the result that they're seeking.
Okay, so that completes the list of questions we wanted to cover. Now it's time for us to switch to the question that we have received from our live viewers from both LinkedIn and YouTube. We'll try to go in the order we received these questions, but there were a couple of questions that were closely related to these last points we just made. So while we have that fresh top of mind, I'd like to bring up this question from one of our, it appears that employer representatives, Doreen. So the question is, the H-1B worker in the U.S. traveling for stamping may travel to get the H-1B visa stamped with caution. And any comments on that, Shilpa?
Again, with caution is a very difficult term to define. At the end of the day, are they safe to travel? Honestly, I remember advice from an immigration judge once to me saying that, Shilpa, when people leave the United States, we don't control when they can come back and how they'll come back. So again, I would just stand by what Katyana said. Unless it's absolutely necessary, please try and avoid travel unless we get some very clear guidelines that people who have approved H-1Bs, go ahead, travel, get your visas. Once I hear that, I feel more comfortable, because if you get stuck overseas trying to defend your position to a consular officer, the embassy officers currently have no direction, no clarity, and everybody's trying to figure this out. Until that clarity comes, please try and avoid travel. If ultimately they choose to travel, they need to be prepared that things can change overnight. And if that happens, that it works to their detriment, that's going to be a problem.
There is a related question from another viewer. This question is about the Canadian citizens who are living in Canada currently, and Canadians typically don't need any visa to enter the US. But if they are looking to transfer their H-1B to a new employer, then will they be impacted by it?
Same answer. Seeking admission is the most important part here. You can seek admission at a port of entry without having to without needing a visa on your passport. Will CBP let them in and say that they're not subject to the proclamation? CBP will go through all the available guidelines and perhaps let them in. But there's always a possibility that there's a CBP officer who disagrees and is like, okay, we don't see a proof of $100,000 payment. We're not letting you in. Before traveling, please have your case reviewed by a qualified immigration attorney. If at that point, on that particular date, they're able to tell you, yes, go ahead, come back, go out, come back, I would only take that chance at that point in time.
And at this point, I want to cover something housekeeping related. For our viewers, please don't share any confidential personal information in your comments. We'll try our best to, of course, not show it on the screen, even if you share, but because it's a live format and you may want to keep something confidential, and we may not always keep it off the stage. So yes, please keep your question more general in nature without any personal confidential information. So the other question we have is related to F1 students on OPT. And I'll project the exact question here. It's in a non-STEM field. Eligibility for J1 visa.
J1 visa is available to individuals who qualify under the parameters of a J1. Without looking at a person's resume and credentials, it would be very difficult for me to tell them whether they qualify as a research scholar or they qualify as a trainee or they qualify as an intern. It's best discussed with the program sponsor, because if the university is recommending a J1, a DS 2019 is issued by the university for the purposes of changing their status to J1. And if the university is in a position to give them a DS 2019, then yes, a J1 is doable, because the university does this for many, many candidates, and they don't offer it unless they believe an individual qualifies.
One more question related to travel. It's from an employer who wants to know if their H-1B employees want to go for stamping, what advice they can offer to them.
Honestly, the answer is the same. Please speak to an immigration attorney before you travel. In my heart, I don't feel safe recommending anybody to travel at this time unless we get further clarity from the Department of Homeland Security that is applied across the board. I definitely don't want to be the reason that these individuals assume that it's okay to travel and then are struck abroad for months. So unless further clarity is issued and we know exactly what's safe and what's not safe, I would refrain from international travel. This is not to create panic. I want to be very clear on that. This is just a word of caution that things are not clear. There's no definitive direction that will be forthcoming, and you may very well be okay to travel in the next few weeks. But until that happens, please stay put.
Okay. The next question we want to cover is from an employer. They want to know whether employees in the US that are currently on OPT STEM fields and they would need H-1B sponsorship, would this fee apply to them, or would they be exempt?
As it stands today, it would apply to them, because we haven't received any directions on the national interest exemption, which is where the STEM field would likely fall. So if it is, and if these STEM OPT employees are going through the lottery next year, anybody who goes through the lottery next year is subject to this $100,000 fee as it stands today. No exemptions have formally been announced by the government.
Okay, there is a similar question about someone who had an H-1B visa in the past, along with an approved I-140, uh, and they are seeking another H-1B job in STEM, and they want to know whether NIW exemption be applied.
Same answer. We don't know. The national interest exemption has not been announced. I'm so sorry, but we have to be very clear. There are answers we do not have today because the government hasn't made those answers available. As soon as they become available, we'll be happy to immediately update through LinkedIn posts as well as website updates and newsletters. But as of today, 1:47 p.m. Eastern Time in the United States, we do not have that clarification.
Okay, so the next question is related to travel as well. Someone with a valid H-1B for at least a couple of years and also an approved I-140. However, her stamp on the passport expires soon, and the appointment for visa is after September 21, of course. So what is the recommendation here related to renewal?
So you mean visa renewal is a different thing anyway. Visa renewal just means that you're going to the US Embassy to renew your visa. Now, the question here is obviously they have an H-1B approved, they have an I-140 approved. The H-1B was approved prior to September 21st. We've heard some reports. Again, I can't say this is 100%, that people who had H-1B petitions filed or approved prior to September 21 are not subject to this proclamation, who are in the United States. But once they travel, how is the embassy officer going to interpret the proclamation is anybody's guess. Maybe they'll say, no, you're not subject to it. You're good. Here's your stamp. Bye-bye. Go back. But there could be an embassy officer. Sorry, we have not received clear guidance on it. We're putting your case under administrative processing. Come back when we have more clarity, which could be a week, 2 weeks, 6 weeks, 8 weeks. Nobody knows.
Okay. The next question is related to PERM. How do these changes affect PERM petitions for H-1B workers who are currently in the US?
I don't believe the PERM process is going to be impacted directly by this proclamation. I do want to mention that PERM audits may become more common to ensure that a fair recruitment was conducted and qualified U.S. workers were considered for the position. So that may be a backdoor way of the Department of Labor to use this proclamation, or they may be instructed to use that proclamation in those ways. But so far, there's been no direct notification that even the PERMs will go through some excessive scrutiny, but it is possible. I did want to also add one point based on the questions that I'm saying, if it's okay, Vishal.
Yeah, please.
There are people who are asking that if they have an I-797B, which is usually for consular processing, are they exempt? If your petition was filed before September 21st, then you are exempt. If it was filed after September 21st, then you're not exempt. Just remember that. And this is for individuals who are outside the US.
Okay, we have about 5 more minutes to cover a few more questions. So let's take this one also from Alejandro about 797B.
That was the one I just answered, actually. The 797B is for consular processing purposes.
Okay, so let's take this one about TN visa.
See, EB, when you have an I-140 approved, you have indicated an immigrant intent. That being said, if we've had TNs approved even with an I-140, the Foreign Affairs Manual do not prevent the issuance of a TN just based on an I-140 approved. But if your I-140 is based on adjustment of status, or if your 485 is being filed or has been filed, then getting a TN is pretty much a no-no. But if you're able to show that your priority date's not going to be current for many years, and you don't immediately have an immigrant intent, and eventually you will be doing consular processing for your immigrant visas, then there is still a possibility that your TN could be approved.
Okay. Katiana, this next question is for you. It's related to the spouses of H-1B holders. Often they need to get stamping, and their expiration dates and travel plans may differ from the original petitioner. What advice can you offer them?
The same, basically, that we've been pushing. At this point in time, the proclamation only affects H-1B holders outside the United States who have not obtained their H-1Bs prior to the effective date. When it comes to the H-4s, they may have different they may have different travel dates than the H-1B holder, but their actual petition is dependent on the principal. So the same rules would apply. If the principal would be, if they look at it and the principal would be susceptible to obtaining or being required to pay the $100,000, they would have to heed caution. Now, again, this is something that, as Shilpa has explained many times, we cannot guarantee how the consulates are going to be applying this. So unless there's an emergency to depart, we would advise and avoid international travel, because again, we do not know how the consulates are going to be applying, how these regulations are, and we do not want to be the reason to put you at risk of staying outside the United States for extended periods of time. So if it can be avoided, avoid international travel for the time being for stamping until further guidance has been released, and confer with an immigration attorney about your specific case, and it could be then you'll be given a better breakdown and more detailed advice.
Okay, there is a question. I'm not sure if we covered this already, but looks like quite a few people want to know whether this new proposed fee will affect the 2026-2027 lottery, and whether the employer should be fully prepared to pay if this fee stays as is.
The answer is a big yes. There's no way to sugarcoat it. So hiring decisions have to be made carefully, keeping in mind these additional costs. Again, I wouldn't sound the alarm. That said, please keep an eye on the news. Everything has to go through a legal process. There's a pretty high probability that the proclamation will be curtailed or controlled in some way. But unless that clarification is clear, the assumption is yes, it would apply. The good thing is we are still in, let's say, October now, because tomorrow is October 1st. So we still have about 3 or 4 months before we really need to start thinking about the lottery registrations. And a lot can happen in the next 3-4 months. So please keep your eyes and ears open.
Looks like we only have time for 2 more questions. One of them, it appears we've covered some related questions, but I'll still go through this. It's from an employer, and it's about one of their employee with a valid stamped H-1B expiring in about a year from now. Can the employee travel outside the US?
Yes, they're free to travel until their stamp remains valid. I do see some names on the questions that I recognize. I just wanted to say a blanket hi to everyone. Thank you for joining the webinar.
Yes, thanks to our VisaNation's existing clients who joined the webinar today. We are here to help and support, and please don't hesitate to reach out with any follow-up questions you have. We understand the anxiety this current proclamation and the environment is filled with, and we'd be happy to provide individual support to our existing clients.
Thank you, Vishal.
And the last question I wanted to pick is this.
The 01? is what somebody would consider. But again, case by case basis. Which country is the individual from? And that said, individuals who are just fresh out of college or just completed a degree a year ago would not necessarily qualify for an O1 unless they have a lot of research and recognition in the field. So while these visas sound really good on Google, the reality is it's not easy to get them. Each case needs to be assessed individually. And our team at VisaNation, the team of attorneys, support staff, the management team, everybody's here to support everybody, all the applicants and employers in the best way possible. But we also don't want to encourage frivolous filings. Please do not fall prey to individuals who will tell you, oh my God, you have a great case. You could have a great case. Get a second opinion before you actually go into all of that investment and time, that money investment, time investment, effort investment that goes into complex visa applications.
Yes, preparation and getting expert counsel is the key. Because of this new, rather shocking development, there's been a multifold increase in internet forums, Reddit, etc., on people, sort of panicking and listening to any advice that is not from attorneys, and then not only that, taking steps to actually go through with the investment of money and time. So, well, with that, I want to thank all of our viewers today. We appreciate you joining us today, and we look forward to seeing you on another VisaNation webinar. Thank you, Shilpa and Katyana.
Of course. Thank you all.
Our pleasure. Thank you, Vishal. Thanks, Katyana.
Thank you, guys.